Good morning, colleagues. Welcome to our meeting today on the 1st of November, 2022. Let me welcome members here at M46, the members at the virtual platform. We have now have the required quorum. Those who were late have now joined as members on the virtual platform. I also want to welcome the Public Protector here at M46. Recognize evidence leaders, Advocates Bauer and Advocate Mayosi here at M46. The support staff, entire support staff with us, members of the media in their various platforms here and in their other platforms. And most important and lastly, the members of the public who are joining us from their various platforms. Thank you very much. Welcome you all to the resumption of our inquiry today. We concluded on Friday with the key decision that we could not proceed on Friday, owing to a discussion we had, but also the request by the Public Protector for more time to be given. The committee acceded to that request, even though not as would have been wished for, but for a limited period of time, and would have agreed that we'll resume today at 10, which is exactly what we're doing. We concluded in saying that today is going to be the leading of the last witness, and then what will be outstanding is the cross-examination of the two last witnesses beyond today, which will be Mr. Jane as well as Ms. Niels van der Merwe. I hope Mr. van der Merwe will be on the platform when he is needed. But before we get into that space, we then agreed that it will be important that we give the platform and the space for the Public Protector to give us whatever feedback that she would have had prepared for us. And therefore for today, it would be important that we start there, because that is going to assist everybody. As we concluded, the Public Protector was very clear on the record that there would not have been any termination of mandate of a legal team, but was equally clear that she needed time to engage and hear out the legal team, to which we acceded. And so we are looking forward to get that briefing. We would have continued with our correspondence, and in brief, the Public Protector would have corresponded with her even yesterday and would have responded in saying that, confirming that she will be here and that detailed explanation will be done here in the meeting. I also would have corresponded with the legal, with the attorneys. We will hear that from the Public Protector, but maybe later on we can also flight the correspondence. Thank you very much, colleagues. Thank you, Public Protector, for being with us again. I now want to recognize you and hand over the platform to you. Thank you.
Thank you, Honorable Chairperson and committee members, and everyone who's part of this process, evidence leaders and Legal Services from Parliament. I will take you through the update and report back on what transpired. As ordered by the committee, I have tried everything in my power to determine, clarify, reconfirm the situation regarding my constitutionally guaranteed right to legal representation in the Section 194 inquiry and the position of my current legal team of attorneys and advocates. As repeatedly stated by me to the committee, it was never the case that any of my legal representatives withdrew from representing me or walked out, as incorrectly alleged by some members of the committee, the parliamentary legal advisor, and some sections of the media who are hostile to me. The legal practitioners merely implemented in the most appropriate manner available in their opinion and in the circumstances, the mandate which they had at the stage, which was only to deal with the postponement application without giving any recognition to the committee as presently constituted and until otherwise advised. So it is indeed so that due to the resultant confusion, misunderstanding and deliberate misinterpretation of what was explained, I was left in a position where the committee needed to know whether or not the legal representatives were intending to withdraw as incorrectly asserted by others. Hence, I made the request to be granted a week to ascertain the correct position, which was unfairly rejected by the committee, which gave me only 1 working day to do so. I now wish to report the progress available in such a short space of time. As far as the attorneys are concerned, although I've yet to be able to have a physical meeting, we discussed over the phone. We had a long consultation over the phone yesterday. And as well, they have sent you a letter as the chairperson. And accordingly, I can now confirm that as reported in the committee last week, they have not withdrawn. They are still my attorneys of choice, Sianeho attorneys, and I've instructed them to write a separate letter to the committee. And I hope that once and for all, that clarifies the position, which remains unchanged. And I must indicate that I think Mr. Sianeho will be on the platform. He's here, but Chairperson, he has a court or an engagement to attend. So I just said to him, let him just log in, and if given an opportunity, Chairperson can see him and then he can excuse us because of the following reasons. I can similarly reaffirm that the advocates, they are still my team of choice as briefed by my attorneys. They remain in place since their brief has never been terminated by me or my attorneys. However, due to short time given to me by the committee and pre-existing commitments, I have not been able to secure a physical consultation with counsel. There is a tentative arrangement to hold an agent consultation upon their availability, either today in the evening or tomorrow, which is the 1st or the 2nd. So the availability of counsel, unfortunately, is that they are not available to attend the committee sittings today, this week, actually. These are the following reasons. Until last Friday afternoon, there were no scheduled committee meetings, which were set, but then we know that the committee sent us the letter, which was saying we were meeting 27 and 28. And for the week of 31 to 4 October, according to the revised program, there was nothing, which was loaded by the Secretariat on the 20th of October. So they were not in a position to set up anything for that. But then what is critical is that due to the directions by the Chief Justice, which we've received on Friday, which I will also share with the committee. My council team is required to compile heads of argument by the 4th of November, covering no less than an unprecedented 7 different cases which have been consolidated by the Constitutional Court, all set down for hearing on the 24th of November. These cases are as follows: an application for leave to appeal instituted by the DA, an application for leave instituted by the President, an appeal by the DA, an appeal by the President, a confirmation application by the Registrar, a conditional cross appeal by the Public Protector, and a conditional application for leave to appeal by the Public Protector. And for ease of reference, I have also attached those 2 directives by the Chief Justice dated 14th and 28th of October respectively. It will be observed that the chairperson acting on behalf of the committee is also a party in and therefore aware of the said Constitutional Court proceedings, which are of the direct relevance to the fate of the Section 194 proceedings. So an appeal record which was lodged by the DA on Friday, 28th October, consists of over 2,000 pages of reading, which will be necessary in the drafting of the required heads of arguments. In addition to all of the above, the team also has to finalize the judicial review application, of which you were notified last week. This week was therefore reserved to deal with other pressing matters, especially what we've received and directed by the Chief Justice and necessitated by the rulings of the committee. You might be able to appreciate that it would be impossible to achieve those tasks and simultaneously do any justice to the last minute proposed sittings of the committee, which involve the cross-examination of 2 witnesses. The council team will therefore only be available from the week of the 7th, subject to all previous arrangements and requests regarding the duration of the remaining witnesses and the recalling of the witnesses. Needless to say, and in the very unlikely event that the council team may have indeed withdrawn, which I said they have not withdrawn, you would have indicated the last time that it would then require the whole process to appoint a new council or attorneys, but that is not the case. And that matter, I hope it has been clarified now. So the incorrect position that my right to legal representation is not absolute was argued and roundly rejected by the Constitutional Court when it unanimously ordered that I must be afforded full legal representation by the practitioners of my choice at this inquiry. In this regard, you are referred to the relevant judgment of the Constitutional Court. I think it was addressed by the legal services as well on Friday. In the event that the committee unreasonably decides to proceed in the absence of my chosen legal representatives, and in spite of the representations made above, I will kindly request that you provide me with the necessary reasons so that the decision be included in the series of reviewable decisions of the committee. Thank you, Chairperson.